See, it's an attempt towards the another topic after adjudication. The earlier one was pertaining to the adjudication wherein all the critical side of section 454 was discussed. The notices, the frequency of notices were discussed, the way the penalties are being imposed, and why the decriminalization is not basically aiming towards ease of business or is not contributing to the ease of business was the main area of discussion as far as the last video is concerned. Now, as far as this video is concerned, it's all about the board. It's all about the duty as a director. And I must say, when a person does not perform for the betterment of the operation or leave betterment aside, if a person is abusing his position on the board, specifically when a shareholders initiate an action for his removal, now whether that amounts to operation or mismanagement, that is something which would like to have with you in today's video, in today's session, I can say. Now, I believe that it's a prerogative of the shareholder, and whatever the shareholders of the companies are basically expecting from the management to perform, that is for the sake of fulfilling the objective of the company. So many a time it happens when the board of directors receive a special notice from few shareholders and shareholders intends to remove a director from the board. Now, whether that removal with a due process of law, now under the Companies Act 2013, there is a procedure which is prescribed. So one who comply with the procedure, so my board of director who is complying with the procedure of 169 and removing a director, and post removal, if that director in the capacity of shareholder approach tribunal under section 241, 242, whether tribunal possesses that power to reverse that action of the shareholder and reinstate that director on the board. Now that is a point. And I've seen in many of the article of association, not today, but I've seen certain article which was framed under the 1956 Act stating that this directors will be the permanent director. Now, whether article of association which is stating that this will be the permanent director, can such article overrule section 284 of the old act which is now 169? I believe again no, there is nothing permanent as far as the board is concerned. Now there are certain exceptions. Now when specifically a director is appointed by the tribunal, a tribunal possesses power under section 242 subsection 2. In such case of operation and mismanagement, they do have power to appoint a nominee on the board as their nominee or nominee director of the NCLT. Now, such director cannot be removed by the shareholder under 169. Otherwise, if a director is on the board holding a capacity other than independent director, very well shareholders possess this power that by passing an ordinary resolution, they can be removed from the board. There is a procedure prescribed which states that you need to mention the reason that why the shareholders or what is the grounds of special notice and why the board of directors have scheduled an extraordinary general meeting. In that special notice, it is prescribed that considering what reasons those who moved that special notice intends to remove a director from the board. So that is basically a requirement when you read 115 with section 169. So that is the requirement. Now again, the another point is whether even that requirement is mandatory. So is it mandatory that a director do something and then only he will be or that person will be punished pertaining to the removal from his position on the board? I again believe that again a removal and the appointment is the shareholder's perspective. So as far as the appointment of director is concerned, when you read 152, it is up to the shareholder to decide that who will be on the board. Of course, there are certain criteria for a listed companies and for a big companies wherein nomination and remuneration committee is required to be constituted. They will be the authority or they will be the, you can say, the decision making authority to check or to have a due diligence pertaining to that candidate who is proposed to be appointed on the board. But to the contrary, in a small companies wherein the shareholders' money is basically deployed in the company and we used to call that money as a owners fund. So they owners very well possess this power. By due process of law, they can remove. See, removal key procedure, I must say, even though that procedure has been complied or not complied, but whether that amounts to operation or mismanagement, that is something wherein I have seen in the Supreme Court judgment of Ratan Tata and Cyrus Mistry, wherein it is clearly stated that removal of director cannot be treated as an oppressive act. And again, the NCLT or NCLAT does not have that power to reinstate the director on the board if the procedure of 169 has been duly complied. I have seen that directors are basically abusing their position on the board. So many a times they remain neutral by not attending the board meeting. But to the contrary, when they want to make the other directors nervous, they at least abuse their power by specifying that they have not received the financials, or they try to approach the bank for freezing of the bank accounts. They try to behave, or they try to dominate over the workers, they try to dominate over the employee. And basically, just because of their position on the board, they try to make the other director conscious for their act, for basically meeting their purpose, for the purpose of meeting their objective. So on the one side, he is not actively participating in the operation. On the other side, just because of he is on the board, he is doing certain act which is not in the interest of the company as a whole, or which is not in the interest of the company's other stakeholder as a whole. In such circumstances, when shareholder initiate an action, though the majority shareholder, see, even otherwise, even a director is a minority shareholder and the controlling directors are owning the majority of the share, if they initiate any action in such circumstances for removal, such a removal, I believe, is not an oppressive act. And if such kind of removal is taken place, such removal cannot be regarded as if it is an act committed by the majority shareholder against the interest of the minority. Because ultimately he is digging his own hole by doing certain act. And if he is facing the result of his own actions, his own deeds, in such circumstances, even he approached the tribunal under that relevant provision of 241 or 242, probably such an application will not survive, specifically on the grounds of removal, because in no means he will get his position back. So it is very settled law if one go through by the judgment of Supreme Court in case of Cyrus and Ratan Tata. That is one of the settled law, I must say, and it is so many judgments which has been passed in this context that nothing is permanent. So specifying the fact that this directors will continue on the board for, or with no tenure decided, with no tenure fixed, and it is the article which is specifying the term that this will be the permanent director on the board. By fixing such term in the article doesn't prevent the shareholder from initiating an action under section 169. So I believe that removal is a procedure which any director may face if that director is not basically acting in the interest of the company as a whole, or leave the interest of the company as a whole, but he should work in the interest of at least the board or the other shareholder. So I must say that 169 is basically a power within the hand of the shareholder, and shareholder at its own will, with or without any reason, may remove a director from the board. So I must say that not without any reason. The reason is, if I'm initiating an action, an adverse action against any director, it is basically a common law which requires me to specify the reason that why shareholders intends to pass such kind of resolution. So with reason, if the shareholders are initiating an action for removal under 169, it is absolutely not considered as an oppressive act, subject to the condition the procedure has been duly complied. If procedure is not complied, even otherwise it is a void process. So yes, to conclude this, it is absolutely not at all an oppressive act on the part of the majority shareholder against the minority director. Thank you very much.